Nguyen, and I'm your host on Inside Vietnam.
This is a fantastic market because of the strength of the population.
A very high level of attractiveness. It makes sense for them to look at Vietnam.
Stabilise, there is an opportunity in Vietnam because it is an emerging market.
You know, there's still a huge amount of foreign investment coming in here, still a huge amount of interest in Vietnam.
Greetings everyone and welcome back to the show. My name is Phi Nguyen and I'm your host on Inside Vietnam. It has been 4 years since Vietnam was accepted to WTO and with it the Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. While there have been some positive developments in the past few years, investors are still facing a few challenges with Vietnam's system for protecting intellectual property rights, particularly in the areas of NIOP practices. NIOP is short for National Office of Intellectual Property. Further challenges include administrative and judicial enforcement of IPR and amendments to its legal framework for protecting IPR and related rights. In order to unveil some of the key challenges and provide the investing community with possible solutions to these challenges, we are joined today by Mr. Chris Vale, Country Manager Vietnam and Hong Kong of Rouse, one of the leading IP law firms here in Vietnam. Great to see you, Chris, and thank you very much for being on the show with us today.
Thank you. It's a real pleasure to be here, and thank you for inviting me.
Let's start the show by going into the governing law of IP and trademark registration and protection in Vietnam, because I'm sure everybody wants to know a little bit about that. I know that the IP and trademark law was introduced in 2006. Has there been any changes or revisions to the law ever since?
Yeah, that's right. In 2006, all the IP law was consolidated into one place. There was an IP law before that, but it was in a jungle of places. So there was a mixture of ordinances, decrees, circulars, and the IP law 2006 brought them all together under one place. So they're all now in one place. And there has been an amendment made in 2009, which was effective 1st of January 2010. So yes, there has been an update. So the
update reflects changes, or does it actually just revise past clauses?
It revises. I mean, if you look at the last 10 years in Vietnam, there's been so many changes. So within the last decade, you've had, you know, the TRIPS agreement. You've had WTO accession. Vietnam signed up to the Berne Convention in 2003 to protect international copyright. It signed up to the Madrid Protocol to protect international trademark registration. And then you had the 2006 IP law, and things just happened so fast. So the amendment to the IP law was just to plug some of the gaps because some things were happening so fast.
So apart from these revisions and amendments to the law, have you actually seen any other positive development in this area in Vietnam for the past 4 years since Vietnam access to WTO?
Yeah, I mean, there's been a number of positive developments, of course, with a booming economy. Everything booms, so you get a proliferation of good things, and I guess you also get a proliferation of not so good things like infringements and copies and counterfeits and so on. But from what we can see, the government and the authorities are making pretty significant strides to address these issues. Of course, they're still there.
So it's good to know that there are positive developments in Vietnam. But let's talk about the challenges, though, because I'm pretty sure a lot of people are concerned about the challenges in Vietnam. What are the challenges, in your opinion, in terms of IP and trademark registration?
First thing is resources. So at the Trademarks Office, as we said, with any booming economy, everything grows. So applications have grown, and with applications you get increased amount of oppositions, trademark oppositions, increased amount of cancellations, just an increase in work volume generally. And that's kind of exploded. So I think the main challenge is for the Trademarks Office, the NOIP, just to cope with that volume.
NOIP would be the National Office of Intellectual Property.
Yeah, that's right.
When you mention resources, though, Chris, are you talking about the number of people that are required to handle the cases, or are you talking about the capability of the people?
Well, I guess it's both, and one follows the others. Another challenge would be Vietnam as a first-to-file jurisdiction.
First to file.
First to file. So that means whoever gets in there first gets the right.
Okay.
And that does present some challenges to international brands if they weren't in there first, because someone gets in there before them and has a right that's a registration, and that becomes difficult. You then have to try and clear it off the register, which takes up your time and your effort and resources, and of course you're paying local lawyers to do that.
So if I'm a local company and I register a well-known trademark first, I will get it. And if you come in at a later stage, you will have to oppose to that application.
Yeah. I mean, that's the way it works in theory. To register, you'd still have to go through a process. So the NOIP would have to accept your registration, but subject to them accepting it.
How long will it take for you to oppose to such a case in Vietnam, though?
Well, it depends. I mean, normally the registration process should be about 14 months, but it's a straightforward one. It's probably taken about 18 months now. And then if there's a complicated procedures along the way, like an opposition, then it can stretch into a couple of years and even beyond. And so
right.
I mean, that's where I guess the challenges are there.
In regards to well-known trademark status, though, the law defined a well-known trademark as a mark that is widely known by consumers in the Vietnamese territory.
Yeah.
Is that right?
That's right.
And how does that challenge your support to your clients?
Well, the standard definition for well-known trademark is well-known to relevant consumers.
Relevant consumers.
Yes.
How do you define relevant consumers?
Well, so it would be consumers relevant to that particular industry. So, for example, if you've got well-known trademark in the lighting industry, then not everyone. It's not going to be known throughout the Vietnamese territory, but it's going to be known to those people within the lighting industry. Make it easier for well-known trademarks if it were more narrowly defined, so that it's relevant in their particular industry.
Since you touched base on that, let's talk about how you would be able to register a trademark in a particular sector. If I'm a local company and I register trademark A, do I have to just register it in the particular sector that I'm in, or can I register it throughout the other sectors as well?
Well, the normal practice would be to register in the specific class that you're going to do business in. It might be one or two classes. You could attempt to register across the whole spectrum. It would be a little bit expensive, and two, you get a certain period of time by which you've got to use that trademark in that particular area.
Right.
So after a period of time, if you didn't use it in every single sector, someone could come along and knock out that trademark. So just purely in interests of business efficiency and cost and so on, you'd register your trademark in one or two classes or one or two services.
What if, say I'm in coffee at the moment and I register my trademark for the coffee category or class, and in a few more years when I develop the brand and the company, I may get into other sectors, and at that particular time I may come across other trademarks that have been registered in my other sectors already. What am I going to do? Well,
that's a good question, and that would be reasonably typical of what might happen. You would hopefully not leave it a few years. You'd be finding out about this, as soon as it happened, and you'd be seeking to stop them doing business with your trademark, and if they have any registrations, then you'd be looking to cancel their registrations. And it would depend on how successful your business has been. So how much evidence of the notoriety of the reputation that you can bring to bear against someone who's trying to use it in a different way.
If they don't register across all the sectors, and just particularly in their sector or in their class, if there is something happening in the future, as in bad faith, for example, would they be protected?
Yes, I mean you'd use this is where you'd use your well-known status or your well-known reputation to try and remove anyone else from benefiting from your goodwill and reputation.
Do you have to prove to NOIP that you're well-known internationally?
Yes, you'd gather evidence, and you'd get that evidence from all over the world. So, you know, evidence of your advertising, your marketing spend, where you've got your registered rights, any cases that you've brought against third parties. You know, you just build up a whole bank of evidence, and you'd put that in your case to the NOIP, and then they would decide whether the weight of evidence is sufficient to decide in your favor.
What about lookalike, those products that are very similar to your trademarks or your products?
Do present a particular issue. I think there's probably two types of lookalikes. One of which should be relatively simple to stop. Not always, and one is really quite difficult to stop. The first one would be something that is using a registered trademark, but not an identical trademark. So, for example, could be Coca-Cola, or if you're looking in the toothpaste area, it could be, instead of Aquafresh, could be Aquafresco. So it's not identical, but it's similar, and you would expect that it would be decided that it's confusingly similar.
Confusingly similar. They are confusingly similar.
Those ones are confusingly similar. So I'd say relatively straightforward and confusingly similar, and in the same business, in the same sector of good. The ones that are really quite hard and you know, infringers in Vietnam, like everywhere else, are getting quite clever. So they won't use the actual mark. They won't use anything that looks or sounds like Coca-Cola or Aquafresh or Panadol or Nurofen or any of these well-known brands, but they will use the get-up. So the packaging will, to all intents and purposes, look very similar. And so, you know, when the consumer is out buying his or her products, you know, they will see that and could conceivably think they're buying the genuine product when they're not.
So how do you protect your clients in those cases?
That would be an unfair competition case. And you can take unfair competition cases direct to the authorities. So to the Department of Science and Technology or Ministry of Science and Technology, or to the court. I would say at the minute, you know, you'd probably get a faster, quicker, cheaper, more certain resolution from the Ministry and Department of Science and Technology. Strictly speaking, you'd want the court to be handling this type of case. Because if you take it to the administrative authority like the Department of Science and Technology, you're asking people who are not legally qualified to decide reasonably complex legal issues, and so that should be the court's jurisdiction. But you know, we've still got a method that works okay at the moment. But you know, I guess if there's one thing that we'd love to see improve a lot would be the court system to deal with cases like that.
Have you handled a lot of these cases in Vietnam so far?
Yeah, we have handled a lot of these cases, and we've taken very few to court. We're just starting to now.
But most of the cases would be international clients against the local?
Well, I would say there's been very few cases so far, but there has been a couple of international against local, but there's been a couple of local against local, and when that starts to happen, you know, you hope that there's more of that, because it's only through using the system that you can improve it. So, I mean, you know, one of the things that, just as a general message to big international companies who are doing lots of business in Vietnam, pick your cases. You know, pick the right one, but take them to court and you know, and push the system along. If you don't like the decision you get, then you appeal and you start lobbying. You know, you get interested relevant interested groups involved. You know, it could be the local embassies or you know, you can lobby relevant departments within Vietnam.